you, Olivia. Morning, everybody. Hope we're all okay. It's pretty miserable here in North Worcestershire. It's just started raining, but hopefully this morning is going to be informative for you. It's difficult at the moment in terms of employment law updates, mainly because there's not a lot coming through the tribunal for obvious reasons in terms of case decisions, and it's pretty quiet on the legislation front. I think the government fighting COVID, trying to deal with furlough, trying to promote jobs in the UK and deal with Brexit all at the same time is probably just about enough for them. So it's a bit quiet on that front. So I've had a look at what I think really could be some updating topics for you. Just to run through this morning, but I'm really happy at the end to take really questions on anything, so don't think it's limited to just what I've gone through. Please feel free to pop anything in that you want to share or you want me to comment on. No problem at all in that respect. So what we're going to look at this morning is a little bit of an update on furlough. I think everybody's probably a little bit tired of the word furlough now, but we're going to have a look at the update on where we are with that. The Kickstart Scheme and the changes that have come into play from the beginning of September with that, and the job retention bonus. Some information on fraudulent claims, because there's a lot of media around that at the moment, and certainly we saw some media in the BBC yesterday talking about fraudulent claims. And I'll talk to you a little bit about our experience and what's happening in the team with issues being raised where employees have been perhaps subjected to work, but also the employer is still claiming through the scheme. So there's quite a bit of that going on, so I can give you a bit of background on that. We're going to talk about quarantine, because, you know, can you go to Greece? Can't you go to Greece? Can you go to Spain? Can't you go to Spain? Well, one minute you're in Portugal and then you can't, and then the next minute you can. So that's all a movable feast. So we need to have a look at that really and how it affects the workplace. Planning. The next couple of things we're going to look at really will be around planning and you guys getting organised. One, for the 31st of October, because obviously with the furlough scheme coming to an end, there's going to be some big changes there. But also local lockdowns. I'm sure shivers went down everybody's spines last night, and will later on today when Boris gives us further information about what's going to happen concerning restrictions which are coming back into force again. But really, local lockdowns, there's been nothing really that local to us that would have affected us, but I think the government will move towards more local lockdowns. So really, from a business perspective, we need to have our little plans in place in terms of what happens if there is a local lockdown, and we can just have a sort of discussion around that. Finally, I'm just going to give you an update with where we are at the tribunal, and the difficulties the tribunal's having in the current climate, and just give you an idea really around you know, what might happen if you've got a claim, for example, and how long it might be before actually it moves forward. So let's have a look at furlough to start with. So we know that the scheme changed again on the 1st of September. The biggest change is the amount that you'll receive from the government, whether it's somebody that's furloughed full-time or somebody that's flexi-furloughed, and that's changed from the 1st of September. So we know that from the 1st of September, the employee still needs to be paid 80% of their usual wages for the hours that they do not work, up to the cap of £2,500 per month. From the 1st of September, the government will only pay 70% of the usual wages, up to the cap of £2,187.50 for any hours of furlough. That means you've got to pay the difference, which is 10% of the usual wages. And on top of that, the employer's national insurance contributions and pension contributions. Remember, the cap that is applied is proportional to the hours not worked. So that means if you've got an employee who works for 50% of their usual hours in September, then you can claim 70% for their usual hours for the hours that they've not worked. So the 70% cap is £2,187.50. 50% of that is £1,093.75. So if they've worked 50% of their hours, that's the maximum contribution you can get from the government. Going forward into October, we know that the contribution reduces down to 60%, with you having to fund the 20% gap plus the pension contributions and national insurance contributions. And what about an extension to the scheme? So we know, we'll all have seen the media recently, number of bodies from a number of sectors lobbying the government to extend the scheme, especially to specific areas that are continuing to be affected, such as hospitality. The government have made it absolutely clear that they will not be extending the scheme. And that's even though we've seen a number of European countries putting further measures in place to support employees and employers all the way through into spring next year. Government have said that's not going to happen in the UK. What they have said is that they will introduce this job retention bonus. So although there'll be no extension to the scheme, I think the government kind of see this job retention bonus as being the saviour, so to speak. And we saw the Chancellor announce that on the 8th of July. We've been advised that there's going to be further information coming out in September about the scheme. We have got some information about it, but as yet we're still waiting for that guidance. Certainly, the guidance that comes out in September will be talking about how you actually make a claim. But the terms of the scheme, so it will only apply to employees that are eligible for the scheme, i.e. you can only have a bonus for employees that have been furloughed. HMRC will withhold payments if there's a risk that a claim is being made fraudulently. Importantly, employees need to remain continuously employed from the end of the scheme, 31st of October, right through to the end of January 2021 to be able for the employer to get the bonus payment. It's also the case that the employees have to earn an average of £520 per month over that period. So it's in line with the lower earnings limit. Importantly, the employee also has to have earned some income during each of those months. So it can't be that they just earned a load of money in December but didn't get any money in November, because again, you won't qualify for the bonus. Only earnings that are recorded through the RTI portal will be taken into account. So it's important that the records are accurate. Most importantly, the bonus will not be paid for an employee who is serving notice, whether that's contractual notice or statutory notice, that commenced before the 1st of February. So that's even though they remain employed at the end of January. So if, for example, you've given notice to terminate somebody's employment at the beginning of December and they're entitled to 8 weeks notice, if they are serving that notice before the 1st of February, you will not get the bonus, even though they've remained employed up to the end of January. If an employee resigns before the bonus is payable, again, the company will lose the bonus. It's a flat rate, as we know, of £1,000, and that's regardless of the amount of pay that the employee actually earns. So do we think that the retention bonus will achieve its aims? Firstly, does the money have to be paid to the employee? Well, this is slightly different to the furlough scheme, where obviously the furlough pay has to be paid to the employee. The bonus is actually a payment for the employer, not for the employee themselves. So therefore, you don't have to use it as a contribution towards wages. What will be the impact if there's a redundancy process which has been commenced? Well, the first thing is that obviously your obligations during a redundancy process is to look at how you can mitigate the effects of the redundancy. So you will need to discuss with employee reps or trade union reps, or directly with the employees, this bonus if it is part of any sort of consultation process. Is it going to be something that you can avail yourself of if you've brought the employees back prior to the 1st of October? It does appear that the bonus will be payable for any employee that's been furloughed, even if they've returned to work prior to the 31st of October. So you should be able to make the claim. There's been some conjecture as to whether or not you should make the claim if your trading conditions have improved. And in my view, this is a moral rather than a legal question. Some of the big boys, so people like Primark, people like John Lewis, are all saying that they won't be making a claim for these bonuses for their employees. But that's because they're probably larger organisations and their trading hasn't been as significantly affected as perhaps smaller businesses. There's no legal obligation, even if your trading conditions have improved, that you cannot apply for the bonus. But what happens if you've got an employee who refuses to come back to work after the end of October? So let's say we've had an employee who's been furloughed. We want them to come back after the end of October, but there may be reasons as to why they don't want to. That might be because of health reasons, or there may still be some childcare issues, although that's going to be hopefully released by the children having gone back to school now. Even though the employees, if they did not return to work, would remain employed by the company, if they were not receiving the £520 a minimum a month until the end of January, the company cannot claim the bonus. So there's some question, isn't there, over what the position would be in relation to pay from the 1st of November onwards if an employee said, I'm not coming back to work and these are the reasons why. Now, obviously, if the employee was not coming back to work because they were displaying symptoms, then they would receive statutory sick pay or contractual sick pay, or if they were ill for another reason, they would do so. However, there is a situation, of course, isn't there, where if that isn't the case, but the employee is not coming back to work, where actually they would not receive potentially any pay at all. In that situation, if they were not receiving that pay, then you couldn't actually avail yourself of the bonus in relation to those particular employees. Do we think that this bonus is going to be the saviour potentially that the government thinks it is? My view is that given that it's £1,000, and yes, it is likely to assist with those individuals who are perhaps lower paid, I don't think it will be enough to keep people necessarily in their jobs. And even if they do receive the bonus from the 1st of February onwards, because they've retained them until the 1st of January, there's a likelihood that there may be then further redundancies towards spring next year, for the reasons that we've all said above, which is that I don't think it will be the be all and end all in terms of retaining people in employment. The Kickstart Scheme. I think we've probably heard of this. This is a scheme which will provide funding for companies to create new 6-month job placements for young people. The government have identified that through COVID, really, the biggest grouping of people in employment that are going to be massively affected are those that are the younger people. And it's part, obviously, of the government's plan for jobs for 2020. So the grant can be obtained and will fund each job placement by paying 100% of the national minimum wage for 25 hours per week, all of the employer NICs and the minimum auto-enrolment contributions that are required if you were to take these placements on. There's also a £1,500 job placement grant for setup costs, support and training. It's also intended that there'll be further funding that can be accessed to try and integrate these employees into permanent employment once the placement has come to an end. As of the 2nd of September, you can now start applying for those grants through the government website, but there is a limitation, and I'm not sure if everybody was aware of this, which means you can apply directly if you're going to create 30 job placements under the scheme, which means you can basically, therefore, if you're a large employer, you're going to create 30 placements, you can apply directly through the website. However, if you are only going to be creating less than 30 job placements, then in order to avail yourself of this grant and benefit, you've got to partner up with others. It could be other people who are local to you in business, other business people that you're connected to, and create this minimum of the 30 jobs before you can apply. That just deals with Kickstart. Let's just have a think about fraudulent claims, because obviously we've seen some media in the BBC yesterday around this. It is obvious that the amount of furlough fraud claims have massively increased. HMRC reported that in the space of 4 weeks between June and July, there were over 4,000 reports of furlough fraud. That's an increase of 53% in the previous month. We've seen the first arrest of an individual in Solihull, actually, on suspicion of £495,000 of fraud under the government's furlough scheme. And my view is, as companies move towards terminating employees' employment, it is likely that we'll see allegations of furlough fraud being brought to the attention of HMRC more and more by those that have been dismissed. So just to give you an idea of what's happening in the team here, what we're seeing is either employees who have been treated very, very badly by their employer and who are bringing grievances because they have been made to work whilst the company is also claiming furlough pay, and that's resulting in grievances. It's resulting in exit discussions and potentially it is resulting in settlement agreements being paid. In the alternative, it's leading to pre-claim conciliation where there's been dismissals of individuals where that's happened, and the individual realises that they can bring a claim against the company by whistleblowing. And again, there's been parts of the team that have been advising employees in relation to those types of claims. So we've got to be cautious, haven't we, about whistleblowing allegations, the reason being that the compensation in relation to whistleblowing allegations is unlimited. So different to unfair dismissal, and could be very, very costly for the business. Also, we've got to be careful if employees have whistleblown whilst they're employed and are then dismissed. That can also be, as well as other claims, an automatic unfair dismissal. So again, we need to really give some serious thought to being careful around what the potential consequences are if the business has not been run as it should be and people have been fraudulently making claims or erroneous claims under the furlough scheme. So on the BBC yesterday, we saw that up to £3.5 billion in furlough claims may have either been fraudulently claimed or paid in error. We all said at the beginning, you know, well, HMRC will be quite relaxed about the fact that they want people to access the scheme. Well, now we're coming towards the end of the scheme. I think we'll see a switch from the government focusing less on that and focusing less on taking action against those that have misused and abused the scheme. HMRC have also said that they believe between 5 and 10% of furlough cash has been wrongly paid. So they're now looking to tackle the abuse and deal with the fraud. They've received 8,000 calls to their hotline, and they're looking at 27,000 high-risk cases where they believe serious errors have been made and payments made inappropriately. If you think you've made an error in relation to your claim, I think probably the best thing that you could be doing is making a call to HMRC and being transparent about that and working with them to decide what you need to do, either to repay or to deal with the error that's been made. So we're going to move now on to another tricky area, which is quarantine, because this is quite a movable feast at the moment. It's becoming sort of part of daily, weekly life, with the government making decisions with respect to which countries are either put on the list or taken off it. And it can be all very confusing and quite difficult for you organising the workplace and understanding what your obligations are to those employees who have got to quarantine. Quarantining is, of course, different to shielding and self-isolating, and it leads to a number of issues. So the types of issues that we need to think about are, for example, what pay the employees are entitled to, what work they're able to do, if any, and whether any disciplinary action might be required. Before we do that, there are excluded workers. So this does not apply to everyone, although it is likely, I think, that for those who are in the audience today, that it will be the case that all of your workers would need to quarantine. For those that don't need to quarantine, they are drivers of public service vehicles for international carriage of passengers by coach and bus, drivers of goods vehicles for the international carriage of goods. If we've got anybody that's doing some international deliveries into Europe, etc., then again, they don't need to quarantine. Workers engaged in essential and emergency works for the rail network. Seasonal agricultural workers who have offers of employment for seasonal work. Workers engaged in essential or emergency works related to water and sewerage services, and workers with specialist technical skills for essential or emergency works in certain sectors, also nuclear personnel. Other than that, anybody else that travels abroad to a country that is on the list will need to quarantine when they return from their holiday. So what happens in that situation? Can you require the employee to attend work? Well, if an employee can work from home and they are not unwell, then they can continue to do so and they can receive their normal pay. That's the first thing. If they're unable to work from home, you as a company, as an employer, should not require the employee to attend at work. And the reason for that is if you are physically encouraging the employee to attend work, then the employee will be committing a criminal offence. Likewise, your requirement for them to do so is likely to result in action being taken against you, with fines of up to about £3,200. The biggest issue you're going to have if you did require your employees to attend at work would be posing a health and safety risk to the other staff, which could result in further litigation from them and a report to the HSE because of your failure to provide a safe working environment. So what if the employee cannot work from home? Do you pay statutory sick pay, for example. Well, employees who are quarantined do not qualify for SSP, so they're not entitled to receive it. If they develop coronavirus symptoms in that 14-day period, then they will need to complete the 14-day quarantine period thereafter, and they will be entitled to SSP. So we've seen a recent change in the law that coincided with the quarantine period increasing to 14 days, which says that if they have to quarantine for 14 days with symptoms, then they will be entitled to receive statutory sick pay. If they don't test positive for COVID, but they are otherwise unwell, then they'll be entitled to SSP under the normal regime, which means they've got to have 3 waiting days before they start to receive the SSP rate from day 4. Or, of course, if they've got a contractual entitlement to sick pay, then they could receive their contractual sick pay entitlement. What if an employee, though, is a member of a household where somebody has travelled abroad? So this isn't the employee that's travelled abroad, but say a daughter or a son travelled abroad, or a member of the family travelled abroad, and they all live in the same household. The quarantine rules only require that the individual who has travelled needs to quarantine, which seems a little odd given that they'd be sharing a house with other people if they've returned from that trip. The household does not need to quarantine, but they will need to self-isolate if symptoms develop, which could prevent the employee from returning to work. So not necessarily because they've travelled, but they may not be able to come to work because of the fact that they've developed symptoms from somebody that has travelled. Companies obviously could take issue with households where an individual within it who's not the employee has travelled abroad and returned to the household where the employee lives. In that situation, if you inform the employee because you're worried, so let's say you're a food manufacturer, and we've seen that a lot of the food manufacturers seem to spread, there seems to have been some outbreaks and spread of COVID. In that situation, you're probably thinking, well, if that individual lives in a house where a member of their family has travelled abroad, I don't want them to come to work and I want them to quarantine and remain at home. In that situation, you're going to be obliged to pay the employee full pay for them doing so. So just have that in mind. What about taking holidays? So if the employee can't work from home, then one option is that you can insist that the employee takes holiday to cover the quarantine period. That's if they've accrued sufficient leave. If they haven't got sufficient leave, then could you allow them to bring forward their holiday from the next holiday year? So we've seen, haven't we, that the legislation has come into force that allows us to say to employees, well, you can carry forward holiday if you've not taken, but this is the other position. This is, can you bring it forward from next year's holiday entitlement to cover this period of quarantine if I'm going to be at home because I don't want to be unpaid and I can't come to work and I can't work from home? Yes, possibly that could happen. However, what you've got to have in mind is that if they bring holiday forward, it's still got to be the case that within the next holiday year, they still are able to take their full minimum 28-day holiday entitlement. Otherwise, you'll be in breach of the Working Time Directive for the next holiday year. So that's only really going to work, isn't it, if you offer enhanced holiday entitlement to employees and it works, they could bring perhaps 5 days forward or something like that from the next holiday year to this holiday year to cover the quarantine or some of the quarantine period. The other option, of course, is unpaid leave. If the employee hasn't got a sufficient holiday, they're not ill, they're not able to work from home, then they may not be entitled to any pay at all and will have to take it as unpaid leave. So could you furlough the employee who has to quarantine? That's another question. Well, technically, if an employee has been previously furloughed prior to the 10th of June, it is open to you to furlough that employee if they request you to do so up to the 31st of October, because obviously after the 31st of October, there is no formal furlough through the government scheme. So if they've travelled and they're having to quarantine and you feel that you're happy to furlough them, technically you should be able to do so. But it'll be interesting to see how this plays out. I'm not sure that that is definitive in terms of what your options are. The ACAS guidance suggests that you would be able to furlough an employee, but also the government's guidance on the purpose of the job retention scheme is that it is to assist employers who cannot maintain their workforce because of operations having been affected by coronavirus. The decision to take foreign travel and to be quarantined as a result of it, I'm not sure whether that meets that definition or not. So regardless of what has been said, I think there is some question as to whether or not furlough would be appropriate. And it might be that we see the government clarifying that position again. If not, I think you need to know that there is a potential risk that you may not be able to furlough and claim for those employees that are quarantined and who you decide to furlough. Obviously, if an employee is now furloughed during September and October, it's going to cost you more money anyway, because you've got to top up the wages and pay the NICs and pension. What about disciplinary action in relation to quarantine? It's unlikely that disciplinary action would be warranted if an employee was simply to take a foreign holiday of their choice where they've booked the holiday. It would certainly be very unreasonable if, for example, a country was locked down while somebody was actually on holiday, and it wasn't a quarantining country at the time that they actually went. Where it's likely to be most appropriate is where the leave has not been authorised, because the company's not authorised the employee to take the leave regardless of whether they were going on holiday in the UK or not. And that does happen. People just say, oh, that's it, I'm going on holiday, whether it's approved or not. Or mostly if the employee fails to quarantine appropriately and puts other employees at risk. So I have a case at the moment where we have disciplined and are in the process of dismissing an individual who did go to a country that was quarantined, came back, claimed to have misunderstood what the requirements of the quarantine were, and met up with a number of employees outside of the workplace during that quarantine period. So it wasn't that they came to work, so there was no breach in that respect, but in that 14-day period they met up with their mates from work and therefore exposed the other employees potentially to risk because of meeting up with them on a social basis. And in that situation we are going to be looking to potentially dismiss the individual for gross misconduct. So just an example of the types of cases that are happening. So that's it really on quarantine. The next couple of subjects really are around you guys planning, because I think there's a couple of areas where you may have done some planning but might need to do some more, or if not, then this is about getting yourself straight now, ready for the end of October. So firstly, what should we be thinking about? Because the 31st of October is looming. That means the end of the furlough scheme, which means you've probably got possibly, I know there's lots of businesses out there who've still got people fully furloughed, even though the flexi furlough came into force on the 1st of July, or you have got people who are flexi furloughed, and both of those options will be coming to an end through the government scheme at the end of October. So we need to think about what impact that has on the business and those returning to work. So you may firstly need to start having a look at your contracts of employment. We know that furlough sat outside of any sort of contractual requirement, because at the time that it was brought in, whilst there was lots of uncertainty around consent, when the axe fell down, the decision was, yes, you needed to get the consent of the employee to furlough them. Whether that was in writing or they had to accept it is another question, but ultimately consent was required. Now, that has been the case whether you've continued to furlough somebody or you've brought them back and re-furloughed them. On each occasion, you will have issued a letter to deal with that consent issue. At the end of October, that's going to come to an end, which means it reverts back to what your rights are under the contract. So if you've not got contracts in place, or you've got contracts that don't provide you with the ability to look at other options, now's the time to start thinking about those contracts, or thinking about what discussions you need to have with the employees to achieve the changes that you need. So, for example, if you haven't got a right to place employees on short-time working or layoff under the contract, now is the time to start negotiating with the employees, potentially to include those provisions in the contract, or to obtain their consent specifically to it applying in this situation after the end of October, where COVID is still an issue for the business. Also, flexibility. So one of the things that I've seen and been advising on regularly over the last 6 months, because yes, we've been locked down working from home for 6 months, is flexibility. So because people have had reduced numbers of people in the workplace, having furloughed some people, you've noticed that employees have picked up other duties. So they may be doing a specific job, but actually they've ended up picking up other duties. So the one thing then with people coming back to work that you might need to think about again is flexibility and how you're going to redistribute duties. Now, you may have a general flexibility clause under the contract, and if you do, have a look at the terms of that and what that provides you to do, what sort of wriggle room you've got in that respect, and what you can require people to do in terms of their duties. If there's no flexibility clause, then you need to start thinking now about what duties you're going to expect people to carry out. It could be that you've had people furloughed and you've made redundancies and you've reduced your number of staff. So again, now's the time to start talking to those people that have been furloughed about how that might impact on them when they're coming back to work and what changes there may be to their duties. So that's going to take a bit of planning, looking at job descriptions, looking at contracts. You need to have a think about where people are going to work. So, for example, if you've had secretarial staff who've been furloughed or admin staff that have been furloughed until the end of October, and you want them to return to work obviously on the 1st of November, but you don't want them to return to the office, then you need to start thinking about how they're going to work from home, what provisions you need to put in place, how will you create a safe working environment, all the things really that you've done for those individuals that may have been working from home in this intervening period. If you've got more people coming into the workplace, will you need to consider changing your start times and shifts more? Will you need to create evening working to split people up, weekend working to split people up? Again, that's going to need you to have a look at your contracts of employment, because if you haven't got the right to require people to work at the weekend or in the evenings, again, that's going to be something that you need to try and negotiate and obtain consent for, so that you can organise your business in the way that you need it to. Do you need to think about new floor layouts and signs and how you're going to arrange the building? Again, it's bringing to the fore things that probably have been put in place in the last few months, but now come to the fore again because of increased numbers potentially coming back into the workplace. Do you need to order further PPE or look at a change in the PPE that's currently in place because of more people being back? Risk assessments, you'll need to think about new risk assessments being undertaken because of the numbers of higher numbers of people potentially returning to work, but also identifying those that are more vulnerable than others in particular. And I think you need to prepare for an increase in flexible working applications, whether they be temporary applications or whether they be permanent. I think working under furlough, being at home under furlough whilst the kids were off made sense. With the children back at school, the areas where I think there will be difficulties if you want to unfurlough people is in relation to school clubs, especially with the change overnight and the limiting again of social gatherings, etc. So from that point of view, it may be the case that you're seeing temporary or permanent applications from people to change the way that they currently work to try and deal with those issues. Moving on now to something which I think really does need to be planned for, especially after the change last night. And I think, you know, if the government can get on top of this wave that's now starting to come through again, then we may not need to think about this. But I think we really need to now have a plan in place. So in your business, be looking now at what happens if there's a local lockdown. Because although they've happened around probably Scotland, we had Leicester, we've had, you know, lockdowns up in the north, I think it's probably likely that that's going to happen more in the Midlands and the south, and we need to be ready for that and how it affects the business. So we know Boris is going to be talking to us later about these tighter measures that they're bringing into force. And we've already seen over the last couple of days places like Caerphilly being locked down completely, pubs and restaurants being closed again, and what impact that has. So we need to think about now in advance what the plan will be going forward. Obviously, if there's a local lockdown, it's going to have a substantial impact on the business. It's all been a bit confusing, I think, recently, with the government saying if you can work from home, you should still do so. But then the government saying, actually, you know, we're starting to encourage people to get back into the workplace. And really from the 1st of August, it was up to companies to decide what steps and measures they needed to put in place to make sure there were safe working environments. So that's all been a little bit confusing, coupled with the government saying that the inner city businesses are struggling because of commuter trade not coming through, and people therefore should be back at work. However, if there is a local lockdown, we need to prepare, your business needs to prepare for the fact that you may have to close altogether. You may be a pub, you may be a restaurant, and they're likely to be the first affected, as we've seen in Caerphilly, to be required to close completely if there is a local lockdown. If that's going to be the case, what plans have you got in place for your staff and presumably at the moment, and we'll look at this in a second, but furlough is the option. But what happens after the 1st of November? You could be required to close your workplace entirely if there is an outbreak. My other half tried to book a restaurant yesterday for next week because of his daughter going to university, and we tried to book it and were advised that actually they'd got a COVID outbreak and therefore they'd closed entirely. Now, that's not a local lockdown, but I can see that where there could be a local lockdown, things like that could happen very quickly and your business would be closed. You need to think about what your contingency plans are going to be in relation to that. Employees may struggle to get to work, so we've been encouraged back to use public transport. Again, if there is a local lockdown, that could result in public transport not being used, which could affect people's ability to actually attend work. If there's a spike in cases, you're going to possibly see lots of employees that cannot attend work because they've got symptoms or because they're required to self-isolate because they live with somebody else who may have symptoms. So again, we're back to that situation and how, therefore, are you going to run the workplace, or how are you going to have work undertaken if they're, for example, working from home? Those who are more vulnerable and originally on the shielding list may not want to attend work because of the additional risk where there's been a lockdown. If there are further school closures, this is likely to significantly impact on employees who cannot attend work and also cannot work from home. Now, up to the 31st of October, we know the scheme is closed to new entrants after the 10th of June. But if you've previously furloughed an employee up to that date and there's a local lockdown prior to the 31st of October, then you should be able to furlough your employees again prior to the 31st of October, either fully or using flexible furlough. But you'll still have to obviously contribute to the wages in the relevant percentage. If you had not furloughed an employee, then those employees are not capable of being furloughed. If you've engaged any new staff, then those individuals would not be able to be furloughed either. Furlough obviously requires the employee's consent. If it's a short-term lockdown prior to the 31st, then employees may be less likely to agree. And if so, you may have to top up to achieve agreement from employees being furloughed. If you cannot reach agreement, then you may have to contemplate redundancies, but that may depend on how long a local lockdown is for, because obviously there's a process that needs to be followed. And if it's locked down, for example, for a couple of weeks, it may not, from a business perspective, be worthwhile you thinking about that. If an employee is furloughed during a local lockdown between September and October, then obviously there will be the additional costs. But what happens if the furlough scheme has ended, or there are employees who do not agree or who cannot be furloughed, having not been previously furloughed? So the legal position is that employees are entitled to pay if they are available for work. This is even if you're unable to provide work. So in the event of an emergency temporary closure, most employees will be entitled to their normal pay, subject to the position in relation to furlough. If you have the contractual right to do so, where there's a temporary short-term lockdown, then you may be able to implement short-time working or layoff, but only if you've got the contractual right to do so. So it's really important to look at your contracts now. How will you get employees to work? If there's school closures, then that may significantly affect many employees' ability to attend work. If they're unable to attend for an emergency reason, then it falls back to the right to emergency time off to look after dependents, but of course that's unpaid. Obviously, employees could be re-furloughed. If they can work from home whilst they're looking after their children, then you may still wish to pay them as normal. If there is a local lockdown, you still need to think about further risk assessments for home working. If employees refuse to come to work because they believe they're in danger, then they're entitled to refuse to come to work, and you need to give consideration as to how you will approach that. So the legal position is if there is an imminent danger, then the employee has a statutory protection not to attend work, and in such circumstances, they are entitled to stay at home on full pay. So I'd suggest this will only apply in circumstances where there's a real risk of the workplace having a COVID-19 outbreak, or the steps are not being taken to keep a safe environment. In those situations, the employee can refuse to come to work and you are obliged to pay them their full pay. Think about providing additional PPE, think about training and retraining of individuals on company policies for cleaning and sanitising. Suspend and discipline employees very quickly who fail to follow the rules. If employees have to use public transport and it's still a viable platform for attending work, then look at adjusting hours so that employees don't have to use public transport during peak times. Look at other ways you can arrange for employees to attend work if that was the case. You may also need to consider engaging temporary workers if you have a number of workers who are unable to attend work. And obviously, you've got the likes of Hewitt Recruitment locally who'd be able to help you with in relation to temporary workers. If you had a business which has other outlets or other branches in areas outside of the lockdown, then you could potentially, depending on the terms of the contract, redeploy your staff into those other branches or locations. Have a look at your contracts, see if you've got the mobility provisions in there to enable you to do that, and that it's an active mobility provision. So the vital things about mobility provisions are that it's okay having them in the contract, i.e. you've got the right to require the employee to work at a different workplace. But if you do not use it as an active clause, then it can become a void clause. So have a look and see what your contract says. Have a look at what you've done in practice to see if you've got that right, if it's possible. You could give notice to employees to take annual leave to cover the lockdown period. So we know that under the Working Time Directive, it's double the amount of notice for the amount of holiday that you require them to take. Or it might be that employees agree to take their holiday during that period so that they get paid for the leave. Obviously, with respect to a lockdown, it will significantly affect individuals again, even those that may be working from home. And you need to think about, therefore, again, engagement and mental health issues and how you can support your employees, because any tightening again of this sort of freedom that we've come to have over the last sort of month or so, or a couple of months, is likely to have a substantial impact again on people's mental health. Finally, the Employment Tribunal, they are trying to list as many cases as possible for video hearings. It's likely that depending on the length of the hearing, cases now will be dealt with as late as 2022 if they're issued now. I talked about that defence that I filed on behalf of a company in December 19. That's been listed for a 4-day hearing in Manchester in August 2021. So that's sort of gives you an idea in terms of the length of time it's taking for listing cases. The amount of redundancies are likely to lead to an increase in unfair dismissal claims and claims for redundancy pay. And of course, we talked about those new types of claims that will be brought for whistleblowing and health and safety dismissals and all of that sort of stuff. It's likely that these types of claims are going to become more frequent, which will again increase the number of claims that the tribunal is trying to deal with at a time when they're already having difficulty with COVID and the reduced numbers of people in the workplace. Judicial mediations, I've done 2 or 3 now whilst we've been locked down. They're still proceeding, and case management hearings are. Remote hearings, however, are likely to be here for some time. All I would say about tribunals at the moment is because of the length of time that it's taking to list claims, certainly on 2 or 3 occasions with clients that I've got, because the period is so far away for the hearing to be listed, it's prompting early discussions about potential settlements. So just have that in mind if it looks like you've got a claim that's going to be heard in a couple of years' time. For that to be hanging over the business is quite something. So that kind of deals with all of the points that I wanted to touch on, and hopefully has set some things off in your mind, thinking about planning and what you might need to do and how you're affected as we go through the next couple of months before everything changes again on the 1st of November. I don't know, Liv, if we've had any questions or if there's anything anybody wants to ask that's not connected to what I've gone through. Open forum.
Yeah, thank you, Sally. Lots of really good information there. So hopefully everyone has been able to take something away from that. But as you've been talking, we have had a number of questions in the chat, which I'm going to read out because some of them have come straight to me privately. So other people might not be able to see them. So I'm literally just going to start from the top. Some of them were put in quite early on, so you may have covered some of it. So if you have, then just say. So I'm going to start from the top then. Do you know, or do you have any guidance on the maximum number of people that can gather in a workplace?
At the moment, it looks as if Boris is going to give us some further information later, but from what I've seen, it doesn't appear that workplaces are covered by this new restriction that came in overnight. I mean, I'm saying that subject to what he says later, but this is very much aimed at social gatherings and not necessarily at workplace, and I'm hoping that that's the case. Obviously, If I'm wrong, I hold my hand up, because he's going to do his announcement later. But the indication that I've got overnight, and I was watching the first delivery at the 10 o'clock news of this, then breaking news came through on BBC, and then followed up this morning. I don't think it covers workplaces, but we'll wait to see what Boris says later.
Okay, thank you.
Can I just say something to that, Liv? What I would say is that something we might have to think about, though, in the workplace is lunchtime, you know, gathering to have a cigarette, 6 people together and all of that sort of stuff. And you might, although it might not apply to workplaces, you just might need to start thinking about separating people at lunchtime and things like that, just in terms of numbers.
Okay, thank you. Can we have some idea how to deal with situations where we have office workers that are coming into the office at some points but working at home at other points, and we want to keep this as flexible as possible, but how do we contractually keep control? Elizabeth, I'm just going to answer that one, which I was going to say in the next 5 minutes or so anyway. We've actually got a specific webinar that we only launched yesterday with Sally, that's going to be specifically about home working and the contractual issues and changes that you'll need to consider. So instead of Sally going into that now, I would perhaps just advise you to book onto that. So for everyone's information, that specific homework webinar, which is free for chamber members, is taking place on the 8th of October from 12 until 1. I am going to send a follow-up email to everybody on this group with a list of webinars and courses and workshops that I think will be of interest to you. So I will put the link to that one in there, but I hope that's okay, Elizabeth. I'm just very conscious we've only got 5 minutes left, and we've got a specific webinar because I know that a lot of people are going to have questions to do with people working at home, coming back to the office, new flexible working contracts and all that stuff. So hopefully that's okay. Next question is, when will the bonus be paid? Is it the 1st of February? That was my first fix.
Yeah, my understanding is it's February onwards. So I think they're going to have to wait, aren't they, to make sure that they've got the information to evidence that people have remained employed until the 31st of January. So it's got to be February onwards. We are due the announcement and the guidance on how you'll be able to make that claim in September. So again, you know, I'm hoping they do it sooner rather than later, but we seem to get these announcements on a Friday afternoon, and they tend to come after I've done a webinar, which I think is really helpful from the government. Thank you for that. So yeah, as soon as we've got that guidance out, we'll be able to be definitive on that, but it's got to be, if you think about it, February onwards in terms of when you make your claim.
Okay, thank you. Question with regards to the Kickstart scheme. If you're applying via a third party as less than 30 jobs for the Kickstart scheme, are you entitled to the £1,500 grant for setup costs and training, or is that only for the main employer?
My understanding, and again, this would be subject to any further guidance that comes out, but my understanding is that it is for you in terms of the setup costs. I will have a look at that. Let me just make a note of that. And if you, Liv, can you just make a note of who that was, and then I can just ping you an email and you can pass it on.
Ruth, I can see you on the screen, Ruth, as well. Are you also speaking to your account manager at the chamber about that? Because we're able to help and point you in the right direction for that as well, if you need any more help and guidance.
Yeah, I wasn't aware of the grant specifically. I haven't looked into the details of it at the moment, but I wasn't sure if it was a grant for individual people, so that's £1,500 per placement, or if that's £1,500 for the entity. And if you're doing it through, say, the chamber would be entitled to that money, but not necessarily you. And would the chamber therefore do a proportion of that cost back to you, or what? If you're looking at training, that's the sort of thing that if you want to put that in place, that's going to be an important factor.
Yeah, no, really good questions.
I'll have a look at that for you. Good question.
Thanks, Sally.
Okay, moving on then. Is it advisable for everyone to be working from home now for a longer period than originally planned? Do you suggest everybody should be doing a full DSE assessment?
Yes, they do. So if we talk about my business, we realise now that it's highly likely that this is here to stay. Certainly, gosh, into next year. And we're not, we're not expecting people to go into the workplace if they don't want to. We're doing full assessments. We're putting packs together for people working at home. They'll have certain equipment for their desks. They'll have certain chairs. So we're doing all of that. I would do that just to ensure that you've absolutely covered your back. And it's what we're doing as a business.
Okay, thank you. Do you have any advice on insurance for working equipment placed at home for home working or covering utility bills? Would this include work gatherings like presentations, etc.?
Should we deal with that in the webinar, Liv? Because I'm just conscious.
I think so.
Yeah.
And actually, I think a few people have replied to Chris in the chat anyway.
Whatever those topics are for the home working, I probably would have covered that anyway, but can we just make a note of those and then I can make sure I cover them off in that webinar for any specific questions on things like that?
Yeah, that's fine. What looks like the last question then, is the bonus only for people furloughed since the 10th of June or anyone who was furloughed since the start of the scheme?
Anyone since the start of the scheme.
Okay. Is that all right, Laura? That was your question. Yeah, cool. Okay. Any more questions then from anybody? If you want to take yourself off mute, you're more than welcome to. While any of you have a little think of any last questions, then I'm just going to run over some of the webinars that I think might be useful. We've got a workshop, which is the employment law update half-day workshop that we're going to be doing, which is going to take place on the 23rd of September. That's with Sally again, and it's going to go into a lot more detail. This has obviously just been a bit of a free taster webinar. That one is £60 plus VAT for chamber members. We've then got a webinar, the home working webinar that I discussed, which is on the 8th of October, again with Sally. That's a free webinar taking place from 12 until 1. And we do have a new half-day training course as well that I thought might be of interest, which is our mental health first aid awareness training course. That's a half-day course taking place virtually online. If you want any information about any of those, I will put a link in the follow-up email, which I'll send around to everybody today. And you can book online for any of those as well. But if you need any more information, then do let me know. Any more questions? Nothing in the chat. Nobody coming off mute. Just lots of thank yous. Okay. Well, with 2 minutes to go, I think we'll call it a day then. Thank you, Sally.